1.4 million people are currently waiting for an asylum interview in this country, some of them for over 7 years. On July 28, 2026, the government decided a huge chunk of them may never get one. If you have a pending asylum application right now, or you know someone who does, I need you to hear this before you assume your interview date is still coming. Because for a lot of people, it might not be. Here's what actually happened. On July 28, 2026, the Department of Homeland Security published a new rule called Affirmative Asylum Referrals Without Interview. It took effect immediately, the same day it was published. No delay, no grace period. In plain terms, USCIS asylum officers can now review your written application, your I-589, your supporting documents, and your background information, and send your case straight to immigration court, without ever sitting down with you face-to-face. For decades, that interview was the standard, practically guaranteed part of the process. Not anymore. And here's the detail that makes this genuinely significant for a lot of people already in the system. This rule doesn't just apply to new filings going forward. It reaches back into the existing backlog. If you filed your asylum case months or years ago and you're still waiting on that interview, you are covered by this rule right now. Not just people filing tomorrow. Let's talk about the scale here, because it's genuinely massive. DHS itself reports more than 1.4 million pending affirmative asylum cases, with an average wait time of roughly 7.3 years. Out of that backlog, DHS has already flagged approximately 444,000 cases, about 31%, as having a possible issue, like a missed one-year filing deadline or a missing entry date in the file. That doesn't mean all 444,000 of those people are automatically headed to court tomorrow. What it does mean is that the government has already identified the specific pool of cases it considers most likely to qualify for this new fast-track referral. To put that backlog number in perspective, imagine every single seat in every NFL stadium in America filled twice over, and then some, just to represent the people currently waiting on this one interview. That's the scale we're actually talking about. And now, a meaningful chunk of that crowd may go from waiting for a conversation to sitting in a courtroom without ever getting that conversation at all. If you have a pending asylum case, or you know someone who does, this is exactly the kind of update worth not missing. Go ahead and subscribe and turn on notifications because we're tracking this story as it develops. Now, before anyone panics, I want to be precise about what this rule actually does and doesn't do, because there's already misinformation spreading about it. A referral to immigration court is not a denial of asylum. It's not a removal order. If your case gets referred under this new rule, you still have the right to present your full asylum claim to an immigration judge, with an attorney if you have one, and that judge hears your case fresh, from scratch. You can still apply for asylum, for withholding of removal, and for protection under the Convention Against Torture in that courtroom. The door isn't closed. It's just a very different door than the one most people expected to walk through. But here's why that distinction matters so much in practice, and why immigration attorneys across the country are raising serious concerns about it. The asylum office interview was designed to be non-adversarial. You sit with a trained asylum officer, often for 2, 3, sometimes 4 hours, and you get to walk through your story in detail, in a setting built specifically to hear it. Immigration court is a completely different environment. There's a government attorney there specifically working to challenge your claim. Hearings are often compressed into a much shorter window. And the practical reality right now is that asylum approval rates in immigration court have dropped dramatically over the past 2 years. A trend that lines up directly with something we covered recently on this channel: the mass removal of experienced immigration judges and their replacement with newer judges who often have far less specialized background in asylum law. 2 systemic shifts: judges with less experience, and now fewer people even getting a first conversation before landing in front of one of those judges, happening at almost exactly the same time, isn't a coincidence worth ignoring. Immigration attorneys are also raising a legal objection to how this rule was rolled out in the first place. Normally, when a federal agency wants to change a major regulation, it has to publish the proposed rule, take public comments, consider that feedback, and then issue a final version. This rule skipped that entire sequence. It was issued as what's called an interim final rule, meaning it became legally binding the same day it was published, even though the public comment period is technically still open, running through September 28, 2026. Multiple immigration law firms have pointed out that applying a rule retroactively to cases that have already been pending for years without going through standard notice and comment first raises real questions under the Administrative Procedure Act, the federal law that governs how agencies are allowed to make these kinds of changes. Whether a court ultimately agrees with that argument is still an open question, but it's already becoming a serious point of legal contention, and it's worth watching whether a formal court challenge actually materializes in the coming weeks. So what should you actually do if this affects you or someone you know? First, understand that your written application, your I-589 and everything attached to it, just became far more important than it used to be. If your case is referred without an interview, that paper record may be the primary thing standing between you and a fair hearing on the facts, at least in that first stage. Review it carefully. If there are gaps, inconsistencies, or missing supporting evidence, that's worth addressing proactively with an attorney now, rather than waiting to see what happens. Second, know that USCIS can still issue a request for evidence even under this new process, and if you receive one, respond to it completely and on time. Third, if your case does get referred to immigration court, that is the moment to have experienced legal representation if you don't already, because the environment you're walking into is materially different from the one you originally prepared for. And fourth, if you genuinely believe your case has been sitting in the backlog long enough that a referral seems likely, don't wait passively for a notice to arrive. Use this window to get your file reviewed now, while you still have some control over its contents. Here's the honest, bigger picture worth sitting with. This rule doesn't eliminate asylum in the United States. It doesn't strip away someone's right to eventually make their case. What it does is remove a specific, decades-old checkpoint in a system where more than 1 million people are already waiting years for basic due process, and it shifts a huge number of those people directly into a court environment that current data shows is granting asylum at historically low rates. Whether that shift survives the legal challenges already forming against it is genuinely still unknown. But for anyone with a case sitting in that backlog right now, the practical reality changed on July 28th, whether the courts eventually agree it should have or not. Go back to that stadium image from the start of this video. Every NFL stadium in the country, filled twice over, just to represent the people still waiting on one conversation. That's not a number most people can really picture. But if you're one of those 1.4 million, it's not an abstraction. It's your file, sitting somewhere in that crowd. And as of July 28th, the odds of what happens to it changed. This video is for general information and educational purposes only, and does not constitute legal advice. It reflects DHS's published rule and figures, along with reporting on legal concerns raised by immigration attorneys, current as of the time of this recording, and further developments, including any court challenge, may change the picture. If you have a pending asylum case, the most important step you can take is having a licensed immigration attorney review your file directly. Before you go, make sure you've hit subscribe and turned on notifications, because we're going to keep following this story closely, including any legal challenges that emerge, how DHS responds to the public comments still coming in through September, and what this actually looks like in practice for people whose cases get referred in the months ahead. If this video helped you understand something that directly affects you or someone you care about, share it with them, because accurate information about exactly where your case stands might matter more right now than it ever has. Thanks so much for watching.